As the Supreme Court begins its summer recess, we take a look back at this term and a few of the High Court's biggest decisions involving religious liberty and pro-life issues. Joining me now on Skype to help us do just that is Amy Howe, co-founder of SCOTUSblog. Amy, welcome back. Great to have you.
Thanks for having me.
Well, Amy, we have a lot to talk about, but I want to focus on a couple of cases of special interest to our audience. Yesterday, we spoke with Sister Constance Veet with the Little Sisters of the Poor about the High Court's decision in their case. What are your thoughts on that ruling and its significance when it comes to religious freedom?
So it's an interesting case because it is, technically not a religious freedom case. The Supreme Court in that case was considering, it ruled that these exemptions from the Affordable Care Act's birth control mandate that the Trump administration created didn't violate the Affordable Care Act, and that when the Trump administration issued these rules back in 2017 and 2018, that it checked all the boxes and crossed all the T's and dotted all the I's as a procedural matter. But obviously, it is allowing these exemptions to go into place. So it's got incredible significance for the employers who will now be able to claim them. And the other thing that the Supreme Court said was that the language of the Affordable Care Act gives the federal government a lot of discretion to decide who gets these exemptions. So even though it's not a religious freedom case in the sense that they're not interpreting the Constitution or the Religious Freedom Restoration Act, it's still obviously very important to the employers who want to claim this exemption.
Yeah, we also saw an important ruling on behalf of religious schools and their ability to hire and fire teachers. Can we talk a little bit more about that?
Sure. That was a case brought by two elementary school teachers in Southern California. They taught at Catholic schools. They were both fired. One alleged that it was because of age discrimination. The other one alleged that it was because she had announced that she had breast cancer. And the Supreme Court said that Catholic schools, schools in general, are going to have a lot of discretion to say what counts as a minister and which employees, therefore, cannot bring employment discrimination suits. A decision by Justice Samuel Alito, the Supreme Court said that really what matters is what an employee does. And so even if a faith doesn't call someone a minister, the person doesn't necessarily have religious training, hasn't gone to seminary, if this person is regarded as serving an important religious role, sort of praying, teaching, then they may not be able to sue their employer for employment discrimination.
Yeah, unfortunately, though, it wasn't all good news. There was some disappointing decisions for pro-lifers when the court overturned a Louisiana law holding abortion clinics to the same standards as other surgical centers. Can we talk about that and the role that Chief Justice John Roberts played in that decision and throughout the term?
Sure. The Chief Justice John Roberts provided the fifth vote, joining the court's four more liberal justices, to strike down a Louisiana law. The interesting thing was that he didn't join the four justices. He wrote his own opinion, and he said, in essence, that a couple of years ago, the Supreme Court had struck down a very similar law out of Texas, and so he was going to also vote to strike down the Louisiana law. But he made the point that it was really, this decision was because the Louisiana law was so similar to the Texas law. So he didn't necessarily say how he would vote if there were other abortion laws that weren't similar to the Louisiana law. And he also made the point that he believed that the test for when an abortion law is unconstitutional is more lenient than what Justice Breyer had described in his opinion for the former liberal justices. And so a couple of days later, the Supreme Court actually sent a couple of cases back to the lower courts, challenges to laws out of Indiana involving ultrasounds, for example. And these were laws in which the cases in which the laws had been struck down by the lower courts, but instead of upholding the laws, the Supreme Court actually sent them back for another look, presumably because they thought that the lower courts had applied the wrong test.
Well, Amy, thank you so much for coming on today. We always appreciate your analysis. Amy Howe, co-founder of SCOTUSblog. Thanks again, Amy.
Thanks for having me.